Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Arohi Kashyap explains the HIPAA requirements that come from doing business in the healthcare industry. She does it using a business associate agreement. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen here with my friend Arohi Kashyap. Arohi, how are you today?
Hi, Mike. I'm doing good. Glad to be back. I've done one of these before, and it's really fun to be back here.
Repeat guests. We need to do that podcast thing where or that SNL thing where the five timers get a special jacket or whatever. We're gonna do that eventually. So you have to come back. There's no jacket yet. Forget it on 2 times, but 5 times. We might be talking about a green jacket. Okay, Arohi, you brought us something interesting today that I've actually never seen before. I'm going to share it with the folks at home. It is called a business associate agreement. This one, I take it, was posted from the Arkansas Department of Human Services. So this is a government on that side anyway. And but what is this document? When are we going to run into a business associate agreement?
So basically what happens is whenever there's something which involves protected health information, or PHI, which I will be saying quite a lot, so everyone please get used to that. But whenever I talk about PHI, or whenever anyone is handling or using PHI, it is a very, very sensitive subject, and it's a very, very sensitive content that you'd be, having one party send to another, and then they're using it for some reason, or even if it's for destruction purposes. When you have this being transferred from a covered entity, which is like a hospital or a nursing home, basically where that content originates, and if they need to give it to somebody who's, going to be using it somehow, or maybe they're responsible for destroying the data, or they're responsible for, somehow analyzing the data, or putting appointments and putting all the information of the patient in those appointments, any of those things, you need a business associate agreement, because while the hospitals and the doctors, the nursing homes, medical insurance providers, they're all bound by HIPAA regulations. And while they're bound by the HIPAA regulations, if they give it to somebody who is not, a medical service provider, that person is technically not bound by the HIPAA regulations until they're brought in as a business associate. And you have to sign a business associate agreement. It says that in HIPAA as well. And you're basically ensuring that, okay, you know what the covered entity does to protect this information is what the business associate is going to do. So it's just a way of making sure that it's kind of like if you have a controller and a processor, and the controller's like, okay, you know what, I'm going to give you data, and you need to analyze it, and you need to work on it, and you give it to the processor, and the processor starts doing their thing with it. You want to make sure that the processor is protecting that information, and you want to make sure that they're finding ways to, either securely handle that information properly, not disclose that information, only disclose it to a certain allowable extent. So for all those things, you have a business associate agreement. And it's solely for, PHI. We're only talking about healthcare here. It's, there are other ways that I'm sure you can use business associate agreements under different names. But particularly here, when we talk about a BAA, we're saying, okay, we have healthcare information that's originated at a hospital, and the hospital needs some help. And they need, somebody to help manage their work, or they need someone to help manage their shredding. And, there are a lot of physical files still there in hospitals. We need someone to help manage the shredding, or we need somebody to help manage our appointment book. So that person or that entity ends up getting all of that information, okay? Or they could inadvertently get, that information disclosed to them. So for anyone who has access to that medical information, for anyone who can inadvertently get access to that medical information, you want to make sure that they sign a business associate agreement.
Okay, so I want to clarify for my sake. It sounds like what you're saying is if we use a term like covered entity, the covering that we're talking about is the regulation, right? The regulation that's saying, hey, y'all are in this bucket. You need to be, we can be explicit about that list, but we know in everyday business activity, you're going to be hiring somebody to walk the dog. I don't know if the dog knows personal health information. But if the dog has PHI, we need to make sure that the dog has a business associate agreement. So they're covered by the purposes of the regulation, if not explicitly covered as a party. Am I understanding that right?
Right. No, absolutely. And covered entity is those are the people who get the brunt of it. So you get the brunt of doing all of the compliances and the filing. And if something gets, if there's a breach or there's a screw up that happens or something that you can't even control, it's the covered entity whose head is on the line. So you need to make sure that anyone that you have contact with, or anyone who gets your data, anyone that, even possibly could get some sort of PHI that you've gotten from your patients, you need to have a BAA with them, because you're protecting yourself, you're protecting the patient, and it's something that you do have to keep on file by law to then, give any kind of authority if there's an issue that happens or there's a breach that happens. You need to have all of those things on file.
All right, we'll talk about specific language in this particular document, but let's start with a few more principles. I want to ask you about, you mentioned, I know in the regulation there are a bunch of rules, and so I want to ask about that before we get to the specific language in the document. Give us some background on that on the regulation, on what's going on in terms of guidelines for the disclosure of the information, for the protection of the information, for data breach. What exists outside this contract that we need to know as we create this contract?
Okay, so HIPAA is the law of the land for anyone who is a medical service provider or a medical insurance company or like a healthcare clearinghouse. I mean, if you're any of the above in any sort of way, you could be a therapist, you could be a chiropractor, you could be a nursing home, whoever you are, and if you're providing some sort of a healthcare service, HIPAA is one of your guidebooks. That is something that's your holy grail. You have to make sure that you abide by every single term that's in HIPAA. It's basically there to make sure that any healthcare information that is there with the healthcare service provider, be it the doctor or the hospital, if they have any kind of information, they need to know how to keep it safe. So they have regulations on, okay, you know what, how are you not allowed to use the data? So for example, you can't get payment for that kind of data. So that cannot be one of the, sets of data that you're selling for money. You can't disclose it to anybody who doesn't absolutely need to know. You have to make sure that if there is any suspected breach, there are bunches of timelines that you have to adhere to. So those timelines, those specific levels of security you need to maintain, restrictions on use of that data, all of that is there in HIPAA. And I think that now more than ever, that's even more relevant, because initially what would happen is in doctors' offices, and this is, I'm going back like 20, 25, 30 years, a lot of the stuff that had to be done was all in-house. So if there needs to be appointment scheduling, it was in-house. Before, this is before Practo existed or any other sort of appointment management softwares existed. A lot of those things were done in-house. So it was easy to comply with a law like HIPAA because you had a lot more control on what you were doing. There have been a lot more people who are able to help out if you need appointment books done, or if you need something like Practo, if there are, lawyers, accountants, medical record companies, IT companies that help you, maybe for marketing, or maybe there's a new software you want integrated with your, other softwares or anything. Because the tech has gone so far, there are a lot more companies that a hospital could be hiring. It could be for, checking a patient's financial records to make sure that they're able to pay, anything. When it comes to all of that, and because it has become so vast, you need to have these BAs in place by law. And it's even more important now, HIPAA as a law, because medical information, especially after, certain judgments have passed, and again, I'm going to be very politically correct here, but after certain judgments have passed, I saw an uptick in the amount of people that were very, very scared about medical information being, put out. And just like on a personal level, I can tell you, when the judgment was passed, and again, very politically correct, there was an increased in a significant uptick in the number of people I had calling me and calling our firm, where they're like, okay, you know what? We have all these contracts, and we have our BAs in place, and we have our systems in place, and we have our policies in place, but we want to make sure we want it reviewed, or we want to make sure we have a BA not just with our medical record company, but we want it with the cleaning crew. We want it with the IT company that does our marketing. They were so worried that even inadvertently, if somebody gets access to any kind of information and what they could do with that information. And this was a lot more in, medical companies that were handling, a certain kind of medical services, fertility companies and hospitals, healthcare providers that have that level of sensitive information. And a lot of people got a lot more scared because there were like all these things coming out that, oh my God, this person's healthcare information got leaked and everything like that. So HIPAA, to cut a long story short, HIPAA is there to protect, the patient. It is there to protect the information that the patient gives. It's there to protect any sort of healthcare information that gets, shelled out. And in order to protect that, they have a number of guidelines that you have to follow. There are a number of mandated regulations that you have to follow. There are timelines that you have to follow. And because it's so intensive and because it is so strict, you have to make sure that, okay, if I am somebody who needs to follow this, and I'm giving my data or I'm giving my patient's data to this person to, maybe log into Practo, I need to make sure that they have to do all of those things with me. And they have to they also have to use those softwares. They also have to adhere to those timelines. They also have to adhere to all of those things because the law has huge amounts of penalties and, financial penalties and a lot of reputational damage that can happen by even one data breach. So I think that's pretty much the background for HIPAA. It's very, very important to comply with it.
Be very afraid.
Be very, very afraid.
Yeah, well, maybe this is a basic question as we transition to the language in the contract, but is the language of this agreement mandated by HIPAA? Meaning, is there a section that says, and all business associate agreements shall follow this language, or is the Arkansas Department of Human Services writing their own business associate agreement?
So what happens is they give out templates. It's not that, oh my God, you have to do this and you have to, like the Arkansas department has given it out and there are other departments that give it out as well. Arkansas department just had a lot more things that were covered in their business associate agreement than other ones that have come out by different entities. But you can make your own, you can have a lawyer draft it, you can, and they can draft it from, the get-go and they don't have to take a template from anywhere. It could be anything. There's no mandate that you need to have this kind of language. The only mandate is that you do need to have it, and it does need to cover the essentials.
Gotcha. Okay. So we could use some semi-authoritative templates from governmental bodies like Arkansas DHS, but you could sort of, as long as you're covering the bases, go draft it yourself. All right. Well, let's start with some of those bases then. I'm going to bounce down to Clause 2. And in Section K, to your point, there's a long section about data breaches. And I just want to give just a little bit of language about this. It says, without unreasonable delay and in any event no more than 24 hours after discovery. And discovery is capitalized because back in definition, it says the first day on which business associate or any workforce member, agent, or subcontractor of business associate knows or by exercising reasonable diligence would have known of a breach. So this breach happens, and here's this fairly long section of what you have to do, both for notification and for mitigation and et cetera, referencing, going back to what I assume is the different HIPAA regulations. What are you seeing here in 2K? Do you like the language? Do you like the breadth of this? Do you like the way it's presented? How do you feel about this section?
I liked the way that it's been drafted, quite honestly. It does, the best part of this clause that I'll tell you that I like is the fact that it's cut down on, it's segregated timelines. So there are multiple different timelines for different kinds of notifications, by when do you need to give certain data, by when do you notify. It also says 24 hours, which I very much appreciate. And I think that's sort of the essence of a data breach clause in a business associate agreement. What's really important in these, and I think that this is something I've seen a lot of people sort of get in, they make a mistake with this, and it does cause a lot of issues later on. In the HIPAA regulations, you have a bunch of different kinds of timelines. You have timelines in which you need to report it to the patient. You have timelines where you have to report it to the authority. You have timelines in which you have to get the investigation done. You have multiple different kinds of timelines. Now, what a lot of people end up doing in data breach clauses, first of all, there's been sometimes where it's not been done at all. And it's like, as per, HIPAA regulations. Never leave it up to just HIPAA regulations. And that is something that I would say is very, very important. When you have a business associate, they are another entity altogether. So it's like me saying, okay, I'm a doctor because somehow I've managed to get a medical degree. And I'm a doctor and I'm going to hire Practo. And I'm going to be like, okay, I have Practo and I have another, clearinghouse, okay? And I have hired a clearinghouse, I've hired a medical record company, I have all of these, really great companies. And I have a BAA with all of them. Now, tomorrow, let's say that the medical record company, there's a breach and some of my patient information has gone out. Now, the timeline that I, as the doctor, am mandated to uphold is the ones that are in HIPAA. What a lot of people end up doing is that either they'll put those exact same timelines in their BAA, or they'll say it's as per HIPAA regulations. The problem with that is it gives you no time. So if you've said that maybe there is a 30-day time period that's in HIPAA, that, okay, by 30 days you have to complete your investigation. So if I say that, okay, you know what, medical record company, you have to complete your investigation by 30 days. That creates a huge problem with me because I'm not giving enough time for me to conduct my own review or my own investigation or whatever it may be on the information that they give me. And I just, keep it that way. And then I'm on a timeline, so I have to give whatever I have and I have to cut short, whatever process that I may have, and I have to immediately give it to whoever I need to do it for. And because HIPAA. So I think one very important thing, and that's why I like this clause because it does break down those timelines, is firstly break down the timelines. Make sure that if I have to say anything for data breach notifications, if you're a covered entity, make sure those timelines are broken down and make sure you give yourself time to review, to go over, to ask questions. Because if maybe there are not many sophisticated companies out there who are going to know exactly what they need to do as a business associate. If you have a company and as a business associate, if you can say that, okay, we're HIPAA compliant, that is a huge feather in your cap. That is a massive, massive thing to be. And a lot of medical service providers are going to want to run to you because you're HIPAA compliant. But you're not going to find all of them like that for several different reasons. And because of that, they're not going to understand either the scrutiny that comes with HIPAA. They may not understand the timelines that come with HIPAA. It could be that they think you could get an extension when you couldn't, whatever it may be. So they'll maybe give you something at the last moment. This is something that I personally have seen, where the business associate is going to give something at the last minute, and the covered entity is going to be like, oh my God, I just got this and I got it just in time, but I have to go over this before I give it out. And I have more questions and they haven't done the review properly, or they haven't given me the information properly, or the investigation hasn't been done properly. Whatever it may be, whatever lag or whatever, anything that's missing, I don't have time to get that. And I just have to send out whatever I have. So the first thing, again, just to cut it to a few points, the first thing is always have a data breach term. Never miss out on a data breach term. It's probably one of the most important terms in the entire business associate agreement. You need to make sure that if there's a data breach, you know. And if there's a suspected data breach, you need to know. You need to know because you need to get your ducks in the row as a covered entity. The second thing is, if you're a business associate, make sure you do research on what you need to do in order to be HIPAA compliant. And the main reason is that if you're not HIPAA compliant and if you mishandle a data breach, it's your neck on the line as well because of that business associate agreement, because you're a business associate, and because it's healthcare information that's been breached. And that is taken very, very seriously. So I'd say business associates, get your ducks in a row, get the information handy, talk to your covered entity. And I think that that's very, very important. Talk to your covered entity, ask them any questions that you need to, and covered entities should be open to, answering and having an open dialogue. The third thing is very, very cautious about timelines. People are going to be very okay, and business associates are going to be very okay with like, oh no, we're okay with any timeline. But it has to balance both. The covered entity needs to have enough time to review something, but it cannot be that you're giving a business associate 2 days for something that would normally take them 10. So it's a very, very fine line. You have to balance both. But I think timelines are very, very important. So I think that would be the last thing about data breach notifications, where just figure out how you can, make a timeline, the amount of time you need to review something, and then just go from there.
Well, yeah, because I'm looking at this paragraph and, hey, great, it puts the timelines on there, but it puts it in a giant paragraph. No one is going to read this. So I kind of feel like at minimum, if you're going to do some information design, that might be a section. Literally, there are timelines. Let's just make some flow charts
Formatting
or something, people.
Important. Yeah, no,
Seriously.
I kind of agree with that. Yeah.
Well, last thing I want to play with here is, and I don't know what the context is that someone would do this intentionally, but you can tell me that. If you look at JNN, it talks about how to use the PHI. It says business associates shall not use or disclose except as necessary to perform obligations under the agreement or otherwise required. And then N states it specifically, business associates shall not directly or indirectly receive remuneration in exchange for any PHI. So apparently they can't take my doctor appointment data and go make millions off of it. What about this language? Is this working in here to comply with the regulations as they are?
So, first of all, yes, they do comply. One thing that I would say is about this language, I would recommend it be a little bit more, I think a little more clear, and just for clarity, and again, it's just about formatting, where to make it more understandable and to make it so that, okay, you are drawing someone's attention to this very, very important clause that they need to make sure that they read, is you have a separate section or a separate area where you talk about restrictions on use of data. And that's what happens in a lot of, data processing agreements. That's what a lot of people do, and even, service agreements. That's what a lot of, you'll see a lot of business associate agreements doing that as well, but, less BAs and more like data processing agreements, where you have a separate clause which just talks about data use restrictions. And that for a BAA is something that I'd say is very, very important, because you address these two things, but you also address a bunch of others. When we go back to just these two, clauses and what they're saying, there are a lot of important restrictions you need to put on the use of medical information. Now, let's take a scenario where you're a hospital, and you've just started out. They're like, 5 doctors working together, and you've, just started your practice, and all you're thinking about is, okay, yeah, we need to get the patients in, we need to treat them, we need to be good doctors, save the world, hoo-ha. And, you're fully in it. And you realize that, okay, yeah, we just started it, so there's a certain financial cap that we have whenever we hire somebody, or when we ever hire any company. So if we're hiring a cleaning service, if we're hiring, because cleaning service is another place where you have to be very, very careful. And just to on a side note, a lot of people don't think about that, and a lot of people don't, that's not the first thing that triggers. When we talk about a BAA, the access of information, that's somebody who is coming and is responsible for the sanitation and cleaning of a hospital. They can inadvertently get a lot of information. So, side note, please have a BAA with your cleaning, service company. But if you have someone like that, if you don't have the finances to hire some really big techie place where they have a lot of experience with BAA, and they just focus and they just work with hospitals and they just work with doctors, the cost of that is, a lot. So what do? You end up going to somebody who maybe just started out. You go that, they don't just cover hospitals, they cover all different kinds of sectors. And you have them doing maybe your appointment books, maybe accountants who don't just specialize in medical practices. Vendors, record companies, medical record companies, again, they would know, but maybe if they're relatively newer, what you have to be very, very cautious about is they are not going to know the exact bounds that they have to keep your data in. And the most common and the biggest trigger finger that everyone has is, oh my God, we have so much data. We have names and we have addresses and we have phone numbers. We have, what kind of surgeries happen the most common, what kind of tests do people do. And it ends up being this thing that, oh my God, this could be a great financial resource because it could be. I mean, think of it this way. If you have a company like Practo, you have everything from what is the name of the patient, when are they getting the appointment with the doctor, what was their last blood report, what surgery are they getting, what the diagnosis was, everything. And you have all of that put into Practo. If you have a similar company and they're like, oh my God, and they're new, and they're like, oh my God, we have so much information. This is great. I know so many people who would love to buy this. There would be, research institutes that would want to buy it. There are marketing agencies who would want to buy this. There are, labs that may want to buy this to know when they should go and tell somebody that they should get certain tests done. It's a trigger finger. And it's like, oh my God, I could do this. What you need to know as a business associate is, firstly, you can't do that. And when you have clauses like these, they make it so that the covered entity is covering their own, liability and making sure that if somebody gets this information and if they start selling it or if they start using it for purposes that are not just for what we've sent it to them for, they need to be told that they can't do that and that liability is on them. Another thing that often happens is people are like, okay, you know what? We want to use this information and that's happening very commonly. It's a very common practice these days where, oh my God, we've got a bot and we have, LLM that we have, or we have a bot and we want to make a chat bot out of something. So let's just fill all of this information in. And the problem with that is if the AI starts hallucinating or if very pointed questions are asked, they could end up giving that healthcare information. So not only do you need to restrict that, okay, you can't sell this information, you also have to very, very clearly in your contract restrict that you cannot use this data for anything except for what I'm giving it to you for. And if you do that, you're in breach. That's not something that the HIPAA is going to cover, but that is something that is incredibly important for a covered entity to be covered for, because if they end up using it for something like the, chatbot or anything like that, that's a breach. And that, again, could be catastrophic. So very, very strict, very, very pointed data use restrictions, like you can't sell this data, you can't use it for anything that's not for what I'm telling you, you can't send it to anybody that doesn't need it. You can't be like, oh my God, you know what? This doctor says that this person has cancer, but it kind of doesn't look like that for me. Hey, why don't you guys look at this? Maybe I could save a life. No, you can't do that because that's a breach. So anything, and medical information is such that if you see something interesting, or if you're like, oh my God, hey, I know this person, or hey, this is a celebrity's medical records, or hey, look at the celebrity, they had their gallbladder removed. It's easy to breach because it's interesting information often. Sometimes it's complete jargon, but sometimes it's very interesting information. So understanding how to restrict that and to keep it in the cocoon that it needs to be, that's what these sorts of clauses do. And I think that having just a general data use restriction clause and, having these two ones that we talked about, they're very spaced out in the agreement. So I'd suggest just having them together and having a holistic data use restriction clause. I think that would be very beneficial.
Well, and to your point, there are stories all day about biotech companies specifically, but even Facebook and Google trying to pay for these chunks of these data sets, and they're paying fortunes, and they're running out, right? And so all this data that is now restricted by HIPAA that these companies could make, billions of dollars off of having that data, the temptations there. Well, that's interesting, and I suspect that this, sort of the regulatory constraints are probably going to change in the age of AI just to be able to feed those machines, but not yet. So I appreciate you bringing that document. That's super helpful. Arohi, for people who want to reach out to you and learn more about your practice, what's the best way to connect with you?
I'm very active on LinkedIn, so please feel free to, send me a connection request or a message on LinkedIn. The link would be given below, and my email address, I'll also have that linked below as well. So, yeah, feel free to send me a message or an email, and I'd be happy to connect.
We appreciate you joining us. This is time 2. You only have 3 more till the green jacket, so we'll see how that goes for you. We will also have your contact information over at lawinsider.com/resources, along with this contract if anybody wants to read it. And if you want to be a guest on the Contract Teardown Show, just email us. We are at community@lawinsider.com. We would love to have you, Arohi. Thank you again. We will see you all next time.
Thanks.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.